Hi, everyone. It's Katherine with Salt and Light Global and the Great Lakes Justice Center. And tonight I have a special update about goings-on at Capitol Hill concerning the Equal Rights Amendment. Our friends at the Family Research Council just alerted us that the Senate Majority Leader intends to hold a vote on whether or not to adopt and ratify the Equal Rights Amendment, the original language from the 1970s, before the end of this week. Now, if you're thinking, how can that happen? It's been years since they started the attempt to amend the Constitution this way. That's a very good question. Allow me just a moment before we talk about what this amendment would actually do to take a broad view of the history of how we got to the place we are now. The Equal Rights Amendment was initially introduced in 1972, and Congress gave the amendment a sunset date of 1979 to either receive sufficient ratification and be published as part of the Constitution, or to simply fail. At first, nearly 30 well-intentioned states quickly moved to ratify the proposal, thinking they were acting to promote real gender equality, which everyone supports. But as more people read the proposal, they learned that the reverse was true. The language endangered women's rights. It endangered the unborn. It proposed extreme risks to religious liberty and to other First Amendment rights. State legislatures set the proposal aside and didn't touch it for almost 50 years, choosing for their inaction to be their vote against this very dangerous legislation. But more recently, state legislatures took it up again, I think mostly anticipating possibly the overturn of Roe. And there were 3 states that took up the legislation: Illinois, Nevada, and Virginia. Virginia became the 38th state to ratify the old language, even though the 1979 sunset had long passed. And after ratifying it, they expected the amendment to be added to the Constitution in spite of that sunset language. However, the Department of Justice ruled that it could not be published, that the sunset had expired decades before, and that if they wanted to pass this amendment, they needed to start over and do it the proper way within the proper time frame. That particular rule of the DOJ from February 28th was upheld in a more recent ruling in February 2023 from the District of Columbia U.S. District Court of Appeals, who rejected the amendment's addition to the Constitution, citing the 1979 congressional window for passing had closed, once again, decades before. Not to be derailed, the amendment supporters quickly took the issue back to Congress. They introduced Senate Joint Resolution 4, and they actually held a hearing on this at the very end of March. And what this resolution does is it would declare the Equal Rights Amendment, the original language from 1972, to be fully ratified in spite of the congressional sunset. And they would proclaim that the original deadline was simply void. However, debates are still raging whether or not Congress actually has the authority to retroactively erase its earlier deadline, whether voting on the resolution constitutes passing a bill or a constitutional amendment necessitating a supermajority of votes, and also whether this process upholds the principles of good governance at all. At Salt and Light Global, we would contend it does not uphold the principles of good governance, nor does it act with transparency or good faith towards the public, who thought this was not an issue because that sunset had indeed expired. There's a lot to be seen about the future of this, but before we continue further, I want to go back and talk about what the ERA, the Equal Rights Amendment, actually does. There are 4 particularly deceitful things about the proposed Equal Rights Amendment. Number 1 is the lie that gender is a self-expression that we choose. The truth that we find in God's word is that gender is an immutable sacred part of our creator-endowed identity. Genesis 1:27 states, "So God created man in his image, in his own image, in the image of God, he created him, male and female, he created him." Coupled with Psalm 139, those who ascribe a Judeo-Christian worldview understand that when we are formed in the womb, God ordains our sex as either male or female, and that sex becomes an inherent part of who we are. Even with all the advancements of modern medicine, a biological male who received all the hormone blockers and gender reassignment surgeries available in our modern world would still have things like a stronger bone density, a larger heart, and greater lung capacity than any biological female. And no matter how many surgeries a biological male goes through or how he views himself, his body will never be able to do the things that a woman's body can, like birth new life. We're made special and independent and different and unique on purpose by our Creator. And to suggest that a behavioral preference or self-identification or biology can account for the sum total of what it truly means to be created male or female in the image of God fundamentally devalues both sexes. There's more to our identity than these simple factors, and our God has a distinct and special purpose for men and a distinct and special purpose for women. Those are things we should not forget. These natural differences are beautiful and worthy of celebration. They should not be erased by forced conformity to bad public policy. Gender is an immutable, sacred part of our Creator-endowed identity. It should further be noted that ignoring the difference between men and women leads to a host of dangerous things, especially for women. If passed, the ERA, as it is now written, would make segregation based on gender as criminal as segregation based on skin color or ethnicity. While we should never segregate people based on their skin color or ethnicity, there are some outstanding occasions for sex-based segregation. For example, in same-sex spaces like dressing rooms, restrooms, locker rooms, and other places where we expect to feel safe, sex-based segregation protects women from sexual predators who have nefarious intentions. The same is true for women's prisons and women's shelters, where exposure to the opposite sex can, in the best of circumstances, substantially deter real healing and recovery. And in the worst of circumstances, it can lead to rape or other forms of violent abuse that are simply unacceptable and intolerable. Further, female athletes would never have a chance to be recognized for their ability, very much like what's happening in the Midwest with powerlifting right now, and a host of other sports that you see in the news on a daily basis. To deny women equal opportunity to have athletic achievement as their male counterparts do is simply wrong. This policy disenfranchises women. It does not provide equality for women. Line number 2 is that women are so-called victims of constitutionally enshrined inequality. This is a blatant lie. The truth is that the Constitution provides equal protection for the rights of all people, regardless of sex. The 14th Amendment is clear, and I'm going to read the exact language. It says, quote, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the law." End quote. Notice the language there. Citizens, person, and person is how they referred to the individuals protected by the Constitution. It is ridiculous and offensive to suggest that women are not protected by this language. To reach that conclusion, one would have to assert that women are simply not people, that we are not citizens. But to say that we are not people is fundamentally mind-blowing. How could you reach that? How could you possibly reach that as the logical conclusion? It's simply not what the Constitution says. The truth is plain. The Constitution provides equal protection for the rights of all people, regardless of their sex. Even societally, it's hard to say with a straight face that women are oppressed victims in the United States of America. We have the same ability and opportunity to vote, to own property, to get an education. In fact, point number 3, more women actually obtain college degrees than men. That does not sound like oppression. We also have the same opportunity to hold public office, to live as people who are single or married by their own choice, and to engage in 1,000 other privileges, just as any other person living in this nation of opportunity has. We are certainly not the victims of oppression as females in America. In fact, great sacrifices have been made by both men and women in ages past to afford the liberties that we now have. And it would be very foolish to undo their hard work by passing something like the ERA that seeks to erase gender distinctions altogether. Line number 3 of the Equal Rights Amendment, it purports that women don't have control over their bodies unless they can get abortion on demand. Let's talk about the truth. The bodily autonomy of a woman is in no way undermined by protecting the bodily autonomy and fundamental right to life of a person still inside her womb. They're both people. They both have rights. If passed, the Equal Rights Amendment would constitutionally enshrine a right to abortion on demand for all 9 months of pregnancy and allow taxpayer dollars to pay for the procedure of an abortion at any point in a pregnancy. Many women, myself included, are horrified at this. We don't want a constitutional right to abortion because we understand how inhumane and barbaric it is, especially in late-term pregnancies. We also understand how dangerous it is, especially in late-term pregnancies. But at any stage, that life is a life that is worthy of defense. Many women would never suggest that the violent and barbaric nature of an act like abortion, an act that murders an innocent unborn child, equates to our own bodily autonomy. For me to have rights, I don't expect other people to have to die, no matter how young or old they are. And I think many women feel the same. Modern women also understand that advocating for life, that those advocating for life are not seeking to control women or their bodies. We simply believe that the human life growing inside of a woman's body deserves protection too. A real, quote, equal rights policy would actually defend the life of the baby as well as the woman and rightly value them both as individual persons, each one worthy of equal protection under the law. A person is a person, no matter how small. Line number 4 from the Equal Rights Amendment, it purports that denying biological sex poses no threat to religious people. The truth is that this law is extremely damaging to religious people, regardless what faith. A constitutional amendment denying the distinction of sex would carry equal weight with the First Amendment of the Constitution and would greatly restrict religious liberty, not to mention create quite a constitutional preponderance. Ratified in 1791 as the foremost issue in the Bill of Rights, the First Amendment to the United States Constitution states, quote, Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech. And it goes on to protect other things as well, end quote. However, to deny that biological gender exists or prohibits religious practice that is based on gender would substantially limit religious conscience and practice. How would institutions that ascribe to the biblical definition of marriage as a sacred covenant between one man, one woman, and their God actually be carried out if the Equal Rights Amendment were in place? Those religious covenants would be inherently considered bias under the law. It would be impossible for churches to faithfully observe that teaching without potentially discriminating against those who live other types of relationships. How could a Christian school deny a teen boy access to the girls' locker room or dormitory without committing illegal gender-based segregation? How could a doctor or medical professional who believes in the sanctity of life have a right to carry out their religious beliefs instead of performing an abortion procedure, if an abortion procedure becomes a constitutionally protected right? How could a surgeon who holds that gender is an immutable sacred part of our creator-endowed identity decline the opportunity to perform a gender reassignment surgery or withhold puberty blockers? These are moral questions, huge moral questions that we will have to answer if the Equal Rights Amendment is passed. The infringements are endless, and when both positions are enshrined in the highest law of the land, it creates an impossible zero-sum game where no rights are well secured. A constitutional amendment denying the distinctions of sex would carry equal weight with the First Amendment if the ERA is passed, and it would have devastatingly destructive consequences to religious liberty. The Equal Rights Amendment was bad public policy 50 years ago, and it remains bad public policy to this day. These are important things that we understand, that we know the truth about the Equal Rights Amendment. If it's moved and rushed to a vote this week on the Senate floor, it will only have to pass the House and the president will sign it into law. And we will now have competing rights that do not protect women, that in fact endanger women, the unborn, religious liberty, and many other things enshrined in our Constitution. It's important that we're all informed and educated so that we can take appropriate measures as we understand them. Please stay tuned into the news and watch our legislative tracker at slgwitness.com for updates about this very important legislation. Thank you and have a good night.